pleasure to welcome you to the 20th Annual Charles L. Ihlenfeld Lecture, made possible through a generous bequest in Mr. Ihlenfeld's will to establish an enduring lecture series focused on ethics and public service, both of which Mr. Ihlenfeld exemplified during his life and through his work. Today, we welcome many distinguished guests, but perhaps most distinguished of all are the three generations of the Ihlenfeld family that we have with us today. Today, we have Mr. Charles Ihlenfeld's son, William J. Ihlenfeld, a 1965 graduate of the College of Law. We have Mr. Charles Ihlenfeld's grandson, Mr. Bill Ihlenfeld II, a 1997 graduate of the College of Law, and his great-grandson, Mr. Charles Ihlenfeld, who took a day off from school today to be with us. So will you please stand so that we may recognize you and your family's generosity. It's really, every year they make a trip down here to the law school to attend this lecture, and we are always so pleased to have the family with us. Unfortunately, Bill's brother Charles is not able to be with us today, but he's with us in spirit, and we always send him photographs and CDs of the lecture, and we will do so today. This family is a wonderful testament to the kind of public service that we're celebrating today with the lecture by H. Marshall Jarrett. But in addition, before we move on to our lecture and to an introduction of the Ihlenfeld series, I'd like to introduce Marshall Jarrett's wife, who's with us today, Marion Jarrett, whom everyone calls Bunny, but I thought I would use your official name. Marion is an emeritus professor now at George Washington University in special education. We're just delighted you could be with us today. As I told you, Charles L. Ihlenfeld was a prominent West Virginian. He practiced law for more than 56 years and was a devoted public servant who contributed to his community, Wheeling, West Virginia, in many ways. But his service did not stop there. He served the profession, his local government. His service included local and federal positions, exemplified by long service on the Wheeling City Council as prosecuting attorney for Ohio County and United States Magistrate Judge for the Northern District of West Virginia. It's a great pleasure to have someone, a graduate of this law school, who exemplified public service. But continuing his legacy, his grandson, Mr. Bill Ihlenfeld II, is now serving as the United States Attorney for the Northern District, and his investiture ceremony is November 3rd. He will serve the Department of Justice under today's speaker and under your leadership, Mr. Jarrett. A 1969 graduate of the West Virginia University College of Law, Mr. Marshall Jarrett joins us today after many years of me begging him to come and speak. 3 is a lucky charm, and on the 3rd request, he was able to fit it into his busy schedule. He is now the director of the Executive Office of the United States Attorneys at the United States Department of Justice. Mr. Jarrett has had a long and high-profile career in public service, dealing with ethics and public policy. Attorney General Eric Holder appointed him director on April 13, 2009. Before that, he was counsel for the Office of Professional Responsibility, supervising investigations of professional misconduct by Department of Justice attorneys, a position you can imagine its difficulty. He has also served as an Associate Deputy Attorney General and as Deputy Chief of the Public Integrity Section of the Department of Justice. In addition, he served as chief of the Criminal Division in the U.S. Attorney's Office for the District of Columbia and as criminal chief and first assistant U.S. Attorney in the United States Attorney's Office for the Southern District in West Virginia. Mr. Jarrett is a recipient of the Edmund L. Randolph Award for Outstanding Service to the Department of Justice and has been conferred the rank of Meritorious Executive in the Senior Executive Service. After having lunch with Mr. Jarrett, I can now see why. He tells me secretly he works all the time. You can see that working all the time has meant that he has committed himself to the federal government, to the public, and to the work of the Department of Justice. His lecture today is entitled, That Justice Shall Be Done, an inside look at America's law firm. Please join me in welcoming Mr. Jarrett.
Dean, thank you for that kind introduction, and thank you for the warm hospitality that you've extended to my wife, Bunny, and me since we've been here. Thank you to the Ihlenfeld family for allowing me to come back home and speak today. Charles Ihlenfeld was a remarkable man, and I can't think of a more fitting way to honor his memory. For me, it's a rare opportunity to come home. I was born and raised in Bluefield, went to school in public schools there. I'm a graduate of this university and this law school, but my roots go even deeper because my father was a graduate of this law school. My wife, Bunny, went to undergraduate school here, and my mother's a graduate of West Virginia University. So you can say that West Virginia and West Virginia University is deep in my DNA. So thanks for having me back. This afternoon, I want to talk to you about the responsibilities of the United States Department of Justice and the special role it plays in our government. Specifically, I will talk to you a little bit about the history of the department, its current operations, and then I'm going to give you a peek inside to look at some of the enforcement priorities that we have, some of the things that we're really worried about in this current world. First, though, let's talk about the history. The Judiciary Act of 1789 created the Office of Attorney General. And at the time, it was originally thought to be a one-person job, not even full-time. It was supposed to be a part-time job for one person to advise the President and the administration. The only requirement was that the Attorney General be learned in the law. Well, the job developed, and pretty quickly, one person couldn't do it. So the Attorney General appointed 13 district attorneys to help him do his job, and they served in the different districts. In fact, those were the first U.S. attorneys. And the department sort of moved along that pathway for a long time until 1870, when after the Civil War, the business of the government really began to expand, and these few U.S. attorneys and the Attorney General just couldn't do the job. So Congress passed the Act to establish the Department of Justice, setting up an executive department of the government of the United States with the Attorney General at its head. And that was in 1870. And that was almost 81 years after the U.S. attorneys had been created. So in a sense, the Department of Justice came after the U.S. attorneys. So, Bill, that's an important point for you to remember, is the U.S. attorney. And we tell the people in Maine Justice sometimes that as well. Okay. As its name reflects, the Department of Justice is charged with seeking justice. This is a unique and special obligation, which is evident by the fact that this is the only department in the federal government that is named for a value, justice. Of this responsibility, Tom Jefferson wrote, "The most sacred of the duties of government is to do equal and impartial justice to all its citizens." And this duty remains the guiding principle to this day. The mission statement in the Act of 1870 is as follows: to enforce the laws and defend the interests of the United States according to the law, to ensure public safety against threats foreign and domestic, to provide federal leadership in preventing and controlling crime, to seek just punishment for those guilty of unlawful behavior, and to ensure fair and impartial administration of justice for all Americans. That foundation still is at the bottom of the Justice Department. But over time, the structure of the department and the workload has changed. It has become the world's largest law firm and the central agency for the enforcement of federal laws and the representation of the United States in federal courts. Currently, there are 110,000 employees in the Department of Justice. 110,000. Now, it might surprise you, though, that out of that 110,000, less than 10% are lawyers. There are 10,000 lawyers in the Justice Department. And why is that? It's because the Justice Department does a lot of other things. You all know about the FBI, but then there's the DEA and the ATF. Those are large blocks of employees. I think the FBI has 30,000 employees. You have 3,000 right down the road in Clarksburg. Then we have the Bureau of Prisons. There are 210,000 people in federal prison, and the staff of the Bureau of Prisons is about 35,000. So when you start adding it all up, you can see that there's a lot of other parts of the responsibilities of the Justice Department that don't really require lawyers' services. Now, I want to take just a minute and talk about United States Attorney's offices, because that's the part of the justice that's sort of the leading edge, the part of the justice that most average citizens come in contact with. There are 93 U.S. attorneys around the country in districts. They're in every state in the Union: the District of Columbia, Puerto Rico, the Virgin Islands, Guam, and the Northern Marianas. The United States attorneys are appointed by the President, confirmed by the Senate, and each U.S. attorney is the chief federal law enforcement officer in the district. West Virginia has two. The Southern District, where Booth Goodwin is the U.S. attorney, and the Northern District, where Bill is the U.S. attorney. Now, to assist these U.S. attorneys, there are assistants, and there's a certain number allocated to each office, and they help do the work of the district. Currently, there are 6,000 assistant United States attorneys around the country in the 94 districts. 93 U.S. attorneys, 94 districts, but that's another story. That's a little interesting historical fact. But the answer is Guam and the Northern Marianas are two judicial districts, but there's just one U.S. attorney to serve those districts. Federal prosecutors have a wide latitude in deciding whom to charge, when to charge, how to charge, and even whether to charge. Recognizing this tremendous power, the Department of Justice has issued guidelines to its prosecutors on when and how it's appropriate to consider charges and when it's appropriate to charge an individual. This guidance is contained in the Principles of Federal Prosecution. All prosecutors are required to read it, become familiar with it, and to live by it. These principles help ensure the fair and effective exercise of prosecutorial responsibility. But the success of our system ultimately relies in the character and the integrity of the men and women in the Justice Department. It's significant to report on how well I think they're discharging those duties. Last year, the conviction rate on all federal felonies in the system the conviction rate was 92.7%. So 92.7% of defendants charged in the federal system were convicted. And I think that number reflects the kinds of discretion and judgment that prosecutors use in determining not to bring frivolous or weak cases. Once a prosecutor has brought charges against an individual, the prosecutor's duty remains above all else to seek justice. This basic tenet is a foundation upon which our values rest. It's best explained in a case called Berger versus the United States, which Justice Sutherland described the duties of prosecutors. And excuse me, but I'm going to read this because it's much more elegant than I can say. It's how he describes the obligation of U.S. attorneys. Justice Sutherland said in Berger, The United States Attorney is the representative not of an ordinary party to a controversy, but of a sovereignty whose obligation to govern impartially is as compelling as its obligation to govern at all, and whose interest, therefore, in a criminal prosecution is not that it shall win a case, but that justice shall be done. As such, he is, in a peculiar and very definite sense, the servant of the law, the twofold aim of which is that the guilt shall not escape or innocence suffer. He may prosecute with earnestness and vigor. Indeed, he should do so. But while he may strike hard blows, he is not at liberty to strike foul ones. It is as much his duty to refrain from improper methods calculated to produce a wrongful conviction as it is to use every legitimate means to bring about a just one. These words are eloquent. I have them framed, and I keep them on my conference room wall to remind me and the other prosecutors who work with me of the awesome duty and responsibility that we have in the Department of Justice. Now, I understand that some of Professor Hardesty's students are here. His professional responsibilities students are here. So I'm going to take a few minutes and talk about another part of the Justice Department. There's an office within the Department of Justice that is tasked with ensuring the Department of Justice attorneys perform their duties in accordance with high professional standards, the kind expected of a nation's principal law enforcement agency. And that is so that the citizens of our nation can have confidence in the integrity of our government. This is the Office of Professional Responsibility, OPR. This office was created in the department after the Watergate scandal. And it was in the 1970s when the Attorney General, John Mitchell, and other department officials went to prison. This is also an office that, as the dean said, I headed for 11 years. To understand OPR, you have to take two different concepts of two different institutions and you blend them together. First, take the West Virginia State Bar Council. Take that concept of an institution over here. Then take, when you watch the police shows at night, about the Internal Affairs Division of the Police Department, the IAD guys. So you take the IAD guys and you blend them together with the Bar Council, and you get the Department of Justice's Office of Professional Responsibility. We hire carefully. We expect our lawyers to do very well, but in the words of Ronald Reagan, trust but verify. OPR is there to make sure that our lawyers live up to high standards. OPR's mission is twofold. It's to hold accountable those attorneys who violate our high standards, and at the same time to exonerate department lawyers who've been improperly accused of misconduct. OPR investigates allegations of attorney misconduct and reports the results of its investigations to the Attorney General and other officials. For those of you in the class, if you're wondering how Department of Justice lawyers get in trouble most often with OPR, here are the top four ways they do it. First is failure of duty of candor to the tribunal. There's nothing that drives a federal judge crazy faster than to think that an attorney representing the United States of America has misled them. We expect our lawyers to have total and complete candor with the court. And if they don't, they're going to get investigated by OPR. Failure to adequately represent the interest of your client. The United States is entitled to have robust and forceful representation on its behalf. As David has probably taught you, you're expected to represent your client with warm zeal. And if you don't represent your client that way, the United States, if you miss a statute of limitations, if you fail to file something timely, if you don't adequately develop your case, OPR will look at you. Failure to comply with court orders and deadlines is the third way. We expect our lawyers to be precise, to be thorough, and to be on time. And fourth, and one that has gotten some publicity recently, and if there's time for questions later, we can talk about that. That's the failure to disclose exculpatory information. to the defendant. It has to be timely and it has to be complete. In the trade, that's called violating your Brady-Giglio obligations. So those are the 4 ways that Department of Justice lawyers get in trouble. Not that it happens that often. In a typical year, I would find professional misconduct occurred 20 to 25 times. Now remember, that's not bad. We've got 10,000 lawyers out there, a lot of them in court every day litigating. Most of the lawyers in the department handle the vast majority of the cases in an exemplary fashion. Now I'm going to shift for a minute and talk a little bit about another place, the place where I now work, the Executive Office for United States Attorneys. We call it EOUSA, which is a mouthful. Sounds kind of like EIEIO, but it's the Executive Office for United States Attorneys. It was created in 1953 to improve the relationship between the U.S. attorneys in the field and Main Justice. EOUSA provides general executive oversight and assistance to the 94 United States attorneys' offices around the country. Now, I told you there were 6,000 lawyers in those offices, but altogether, the total number of employees in those offices is about 11,000. EOUSA provides legal counsel and advice to the U.S. attorneys' offices. My office also works on legal policy. The Department of Justice has all kinds of issues relating to legal policy and how we formulate our policy. And my office works representing the interests of U.S. attorneys in the formulation of law enforcement policy. The budget for next year is about $2 billion. I'm what's called a fiscal officer. I have to sign a document saying I'm responsible for that money. I take that very seriously. I want to make sure it's spent the way Congress wanted it spent, the way the President wanted it spent, and I want to make sure that it's not wasted. But that's the budget for U.S. attorneys for a year. Another thing that I'm responsible for that you professors will find interesting is I'm responsible for the Office of Legal Education. We have a very, very sophisticated system of training our lawyers. The Office of Legal Education conducts a majority of the training of our lawyers at the National Advocacy Center in Columbia, South Carolina. It's on the campus of the University of South Carolina. We teach about 200 courses a year on a variety of legal issues and trial advocacy skills. We train about 14,000 people every year. The caliber of the faculty and the use of sophisticated videotaping facilities provides students with a unique training experience in trial and appellate advocacy. In addition to doing on-site training in South Carolina, we also have a television system, and we make provide television communications with most of our offices, and we can put television shows right on their desktops. And we have a library of about 300 training videos, and we can make those available to our prosecutors right on their desktops. So we really try to stay up to date. Another thing we do there is a couple of years ago, we created the Justice Leadership Institute. It dawned on us after some bad experiences that some of our managers weren't that good. We took the very best trial lawyers and we promoted them and we made them managers. And guess what? Some of them weren't very good at it. In fact, some of them were darn right bad, and some of them didn't like it. So we decided that we need to train the next generation of leaders in the Justice Department how to be legal executives. It's a whole different skill set than practicing law. You know, we promote the best trial lawyer. He's the best guy. He could cross-examine. He could rip people up and down, tear them apart on the stand. Well, you know, that's not the skill that you really want, to have someone develop a kind of a warm environment where people feel self-fulfilled. So we have to train them. We retrain them so they can be good managers. So we have a vibrant Justice Leadership Institute to really develop the whole next generation of legal executives to run law firms and run law offices. I've also created a Scholar in Residence program. I wanted to amp up the academic side of OLE, and I'm in the process of interviewing the final candidates for the Scholar in Residence program, and I'm very excited about that. Now, let's see, I want to talk about statistics a little bit. The United States Attorneys community is really a busy place. In fiscal year 2010, which concluded last month, we filed a record number of felony cases. Forget the misdemeanors, there's bunches of them, but just felony cases. Last year, across the U.S. Attorney community, we filed 68,500 felony cases against 91,000 defendants. This is almost a 30% increase in cases from 10 years ago. What's the nature of that work? How do those cases break down? Well, the largest number, some of you may be surprised, are immigration cases. Last year, we filed 29,000 felony indictments in immigration cases. That was followed by 14,000 drug cases, 11,000 cases involving violent crime, and over 6,000 cases were white-collar crime offenses. Now, in addition to those 60,000 plus criminal cases, we also have a very busy civil docket. And last year we handled 80,000 civil cases. We also handled another 60,000 misdemeanor cases. So U.S. Attorney's offices are very, very busy places. So with that as sort of as a statistical backdrop, now I want to give you a peek inside the department at the kinds of things we're worried about, the kinds of priorities that we have initiated, the kinds of programs that we're using to address the issues that we see most compelling in the current environment. I want to tell you a little bit about what we're doing about terrorist threats, combating economic crime, disrupting and dismantling major drug trafficking organizations, fighting health care fraud, and investigating and prosecuting cybercrime and public corruption. Let's start with terrorism. First, I think as all of you know, preventing terrorism and ensuring the public safety of Americans continues to be the department's highest priority. After 9/11, President Bush said to Attorney General John Ashcroft, "Never let it happen again." This directive from President Bush to Attorney General Ashcroft resulted in a major reordering of law enforcement priorities and redirecting of law enforcement resources. One of the first changes was to tear down a wall that existed between the criminal investigations and the criminal cases on one side and the intelligence collection and the intelligence development on the other side. We were so focused on not tainting any of our criminal cases, we erected this huge big wall. So one side didn't talk to the other side. Two separate worlds. First thing, down came that wall, and the two sides started talking then, and they've been talking regularly since then. That has a number of wonderful pluses to make America safer, but for us criminal prosecutors, we're trying to decide how we meet our discovery obligations in national security cases. It makes our world much more complicated. And we then took every U.S. Attorney's office and we put a terrorist and national security expert, trained him, and put him in every one of the U.S. Attorney's offices around the country. Congress and the Department created a new division in the Justice Department, stood it up, called the National Security Division. And one of the division's missions was to synthesize and coordinate criminal enforcement, intelligence collection from both sides of the House. Now, when we have a situation, I'll call it a situation, there are a whole range of options that the government has. And the options run from a traditional criminal prosecution to a prosecution in a military tribunal, to a range, to a surveillance. When we have all kinds of sophisticated surveillance techniques, we'll just watch them. And we may watch them for several years to see what other information we can collect, to military solutions. And it's all part of a toolkit that the administration has in addressing terrorism and terrorism threats. Now, on the criminal side, last year we filed 236 cases involving terrorism or national security cases against 385 defendants. That's a 22% increase over the year before. And we'll continue to do those cases. Now, just an observation that I want to make here. by my calculations, since 9/11, only 14 Americans have been killed by acts of terror on United States soil. There were 13, and they were all soldiers, killed in Fort Hood. The shooter, the psychiatrist, killed 13, wounded others, killed 13. They were all soldiers. And there was an attack on the Little Rock recruiting station by a shooter who killed one soldier and wounded another. So those are 14 dead since 2001. I wonder how many of you who recall vividly 9/11 would think that 9 years later, only 14 Americans would die on American soil. I certainly didn't think that. I thought the number would be much higher. I thought that we'd have more attacks between then and now. But we haven't. And maybe we're lucky. Maybe it's a lot of hard work. But that, I think, is a pretty remarkable record. Now, not that we're not concerned. We're concerned, but we're not just concerned about New York and Washington. We're concerned about all of America and attacks that can occur anywhere. The Department of Justice is fully committed to preventing acts of terrorism before they occur. That's what the goal, keep them from occurring. But we will use our criminal prosecution tool as one of the ways that we'll try to prevent terrorist acts. Next, I want to tell you a little bit about financial fraud. That's another matter, another issue that we're worried about preventing financial fraud and addressing financial fraud. Financial fraud takes many forms. Corporations may cook their books. Mortgage companies may misstate a home buyer's assets to cheat the banks. Companies and individuals may lie to get stimulus money. And unscrupulous individuals may swindle the unwary in shady investment schemes. The financial crisis that we're all experienced have exposed frauds that have decimated pocketbooks and eaten away our retirement accounts, stripping us, Americans, of our confidence in our fiscal security. One of the most serious crimes that we've encountered in this current economic crisis is mortgage fraud. We have seen mortgage fraud schemes that resulted in dozens of foreclosures and millions of dollars in losses, as well as fraudsters who have bankrupted entire companies and national lenders who were not playing by the rules. In response to this crisis, President Obama created a task force with the Attorney General at its lead. It's called a Financial Fraud Enforcement Task Force, which is composed of senior-level representatives from more than 20 federal agencies, as well as state and local partners. I've gone to some of the meetings. This is classic Washington. 20 agencies, you go to a meeting, there are probably 150 lawyers, all sitting in a room, all trying to agree on strategies about how we address this problem. Well, we're doing pretty well, and we're making a difference. In FY 2010, that was just over, the number of mortgage fraud prosecutions are up 145% over the year before. The Financial Fraud Task Force is completing a financial fraud sweep called Operation Stolen Dreams. This is a 3-month operation that could end with a sort of identifying and prosecuting a total loss of about $3 billion. Additionally, we have thousands of mortgage fraud cases in the pipeline, and a vast majority of those cases show a loss of over $1 million. Fraudsters continue to prey on the weak and the desperate. The current fraud du jour, the one that we're seeing right now, focuses on homeowners who are behind in their mortgages, and these fraudsters come in with loan modification scams and short sales fraud schemes. And so folks are already down on their luck. The fraudsters come in and sort of pick over the bones and strip them of even whatever else they've got left. Now, another facet of the mortgage fraud problem involves foreclosure fraud. In the last 2 weeks, it was announced that the task force is examining whether banks and other lenders violated federal law when using fraudulent court documents to foreclose on homes. This investigation is focused on whether financial firms misled federal housing agencies, which insure a large number of homes, and whether such firms committed wire fraud or mail fraud in filing paperwork. Another issue that we're very worried about is the southwest border. As you've seen in the news, we have serious law enforcement problems on the southwest border. Drugs and now some violence are coming north, just flowing north, and guns and drug money are flowing south. The recent data I've seen is that 70% of the guns seized from criminals in Mexico that can be traced were sold in the United States, and they flowed across the border. Mexican drug cartels are vying for control of smuggling routes to the United States. Cities like Juarez and Tijuana have seen dramatic increases in violence over the past few years. This violence includes killing of rivals, police, military officials, and journalists. In 2009, the number of Mexican drug-related homicides was 8,000. And while this violence has largely been south of the border, we're worried about it moving north and spilling over the United States. I'm going to tell you about 3 cases that sort of typify or exemplify the problems that are faced by the Calderon government in Mexico. And President Calderon, I believe, is a very brave man, and he's, in a sense, staked his presidency on doing something about the Mexican drug cartels. 3 weeks ago, a U.S. citizen was shot and killed while riding a jet ski in a lake on the border between Texas and Mexico. His wife was on the lake. They still haven't recovered his body. The Mexican government assigned 2 prosecutors to investigate the case. A few days later, the prosecutors disappeared, and their bodies were found murdered. Last year, U.S. consular officials in Mexico were ambushed after leaving their children at a birthday party. It was 2 different couples. Drug dealers ambushed them, killed 2, wounded another. The third case last year, the situation is such in Mexico that the government has to use soldiers in the army sometimes to conduct these drug raids. There was a very successful drug raid, which large numbers of a cartel were captured, but one of the soldiers was killed. Now, standard operating procedure in Mexico is to keep the identities of the soldiers or the participants in the drug raids confidential. But because this young soldier was killed and he was a hero, the state decided to give him a state funeral. And in the course of the state funeral, they identified his identity was revealed. The next week, cartel members went to his parents' house and murdered almost all of the members of the family. Now, in response to this serious threat, the president has formed a strategy of doing 3 things. We're increasing our security on U.S. citizens along the border. We are taking substantial steps to reduce the flow of contraband, primarily drugs, entering the United States. And at the same time, we're trying to reduce the flow of weapons and illegal cash going to Mexico. We are doing this by focusing our law enforcement resources on partnering with Mexican officials and by targeting the drug cartels. We are actively training federal prosecutors and federal agents. There are EOUSAs who speak Spanish in Mexico right now, training and helping the prosecutors in Mexico develop their skills to go after the cartels. And we are teaming up with those Mexican prosecutors, and we are targeting those Mexican cartels big time. Our goal is to build cases here in the United States and indict them here, arrest them in Mexico, extradite them to the United States, and try them under our drug kingpin statutes, where the penalties are such that we believe we can get life sentences. And under the federal sentencing program, life means life. And that's our goal, and we're going after the cartels. Public corruption. Public corruption is very important. It's another one of our priority areas. Rooting out corruption among our public officials is essential to our democratic institutions. It is important that the citizens of our nation have full confidence in the integrity of the government. The Department of Justice has a special obligation to investigate and prosecute public corruption matters because state and local enforcement resources typically can't do those kinds of cases. They're too complex and too time-consuming. Consequently, the Department's efforts in this area must be comprehensive and vigorous. This is something I know about. I spent 8 years in the public integrity section. I used to fly around the country and prosecute public corruption cases. They're tough, they're difficult, and they're very important. Two excellent examples of these kinds of cases I'm going to point out to you happened just in the last couple of weeks. One in Puerto Rico and the other in Alabama. Earlier this month, arrest warrants were executed in the largest police corruption investigation in the Department of Justice history, known as Operation Guard Shack. 133 individuals, including 90 police and law enforcement officials in Puerto Rico, have been charged and arrested in indictments with conspiracy to distribute cocaine and possession of firearms during the commission of a drug trafficking offense. These indictments are the result of undercover drug transactions that FBI agents conducted across Puerto Rico. The indictments allege that the defendant officers provided security during undercover drug deals in exchange for payments of cash. The police officers altogether received more than $500,000. The same week of those arrests, in Operation Guard Shack, 11 people were arrested in Alabama for conspiracy to manipulate the democratic process for personal gain. The defendants, 4 current Alabama state senators, 3 lobbyists, and 2 owners of a business, have been charged in a conspiracy to buy and sell votes in the legislature on a pro-gambling legislation that would directly benefit the businessmen. So these are 2 cases that exemplify our commitment to public corruption cases. Now, Nadine, how much? I want to leave time for questions. So, okay, all right. I want to talk about health care. Health care fraud is another real problem. It's a real priority for us as well. We want to ensure that health care dollars are not stolen through fraud. Some experts estimate that $63 billion is lost every year to waste, fraud, and abuse. The department is actively fighting health care fraud all across the country. Earlier this month, 73 defendants, including a number of alleged members of an association of American Armenian organized crime enterprise, were charged in indictments with various health care fraud-related crimes involving more than $163 million in building. That's the largest Medicare fraud scheme ever perpetuated by a single criminal enterprise. Now, one of the ways we're going after health care fraud is we've teamed up with the Department of Health and Human Services, and we've created something called HEAT teams. They are health care fraud prevention and enforcement action teams. We take assistant United States attorneys, Department of Justice criminal division lawyers, and investigators from Health and Human Services, and we target health care providers who we think are committing a lot of fraud. Now, the way we do it is we mine HHS billing data to detect statistical anomalies by using metadata analytical techniques, some of the techniques that we used to use on the intelligence side. And we are mining this metadata on Medicare and Medicaid and finding these statistical anomalies. For example, we'll see in a community that there's suddenly a huge spike in prosthetic devices. 20 times, 50 times what we call the national background. And we'll know that there's a billing mill, a healthcare billing mill in that district, jacking up the numbers, charging for medical services that aren't necessary. That's just one example. We have bunches of those. Infusion therapy is another one. There are a whole bunch of them. But so far, these HEAT teams are operating in 7 cities. We've already charged 465 defendants with defrauding Medicare of $830 million. We've also recovered $3.6 billion in lost fraud. Cybercrime. I'm going to quit pretty soon, so we have questions. Another priority enforcement area is cybercrime. And we're very much interested in crime that occurs on the Internet. Technology is moving rapidly, and with this new technology, there are opportunities for criminals. The opportunities abound, whether they're professional hackers, international crime syndicates, or foreign government, or pedophiles. Cybercrime is a serious challenge that requires the government to adapt, respond, and be proactive. Cybercrime comes in many types: intellectual property crime, computer hacking, and child porn. Increasingly, cybercrime is coming from offshore. We are concerned that some of the intellectual property thefts may be state-sponsored, and we are concerned that some of the more common forms of cybercrime are being spawned by international organized crime. In recent years, we've seen a dramatic increase in the number of cases involving crimes against children. The expansion of the Internet has led to an explosion in the market for child pornography. The anonymity afforded by the Internet makes the offenders more difficult to locate and makes them bolder in their actions. Investigations show that offenders often gather in communities over the Internet where trading of these images is just one component of a larger relationship that is premised on a sexual interest in children. This has the effect of eroding the shame that typically would accompany this behavior and desensitizing those involved to the physical and psychological damage caused to the children. To address this problem, we created Project Safe Childhood in 2006. It's an initiative aimed at combating this kind of crime. We partnered with state and locals. We've also partnered with the National Center for Missing and Exploited Children. Under this PSC program, the number of these cases that we brought have increased dramatically. In U.S. Attorney's offices from 2006 to 2009, we have prosecuted over 9,000 of those cases. Now, as the director of EOUSA, one of the things I worry about are our prosecutors who are doing these cases. We have about 200 dedicated prosecutors who are bringing these cases and spending a lot of time and they're very committed. But I am very concerned about the potential effect that viewing these disturbing images can have on the mental and emotional health of our prosecutors. To address this concern, we are partnering with the University of South Carolina School of Medicine to study the effects and develop coping strategies. Indian country. There's a terrible problem in Indian country. An important responsibility of the Department of Justice is its obligation to uphold the laws of the United States in Indian country. There are 56 million acres of Indian country and 565 federally recognized American Indian tribes in the United States. 44 of the U.S. Attorney's districts have Indian country in them. In many states, the state and local law enforcement authorities do not have any law enforcement jurisdiction on the reservations. The only law enforcement jurisdiction is the tribal authorities and the federal government. Violent crime in Indian country is at an unacceptable level, and it has a devastating effect on the basic quality of life there. Many tribes experience rates of violent crime far higher than most Americans. In fact, some murder rates against American Indian women more than 10 times the national average. Sexual assault and domestic violence against American Indian women is also a serious problem. We're trying to do something about that. The Attorney General has directed the 44 U.S. attorneys to develop plans to addressing the problem and reach out to the communities to try to make a difference. We just sent $6 million worth of new prosecutors out to Indian country to prosecute these cases. In addition, the Department has just awarded almost $127 million in grant funds to enhance law enforcement, bolster justice systems, prevent youth substance abuse, serve sexual assault and elder victims, and support other efforts to combat crime in Indian country. And now, before I close up, those are such a good summary, a look inside at the things that we're concerned about, the things that we're worried about. But before I take questions, I wanted to do one thing. I wanted to give you, law students, some advice about how to have a successful legal career. Over the course of my career, I have supervised and worked with thousands of attorneys. Some of them have done exceptionally well, and others not so much. I have observed that the ones who did very well shared 6 characteristics. And so from me, who's practiced for a long time, to you who are on the front end, think about these 6 characteristics. First, the successful lawyers followed their passion. You should think about the part of the law that you love, the part that excites you, and you should follow that path in the law. It took me a long time to find mine. I'd been out of law school 6 years. I remember it's just like yesterday when it happened. I stood up in a federal court in Charleston, West Virginia, and said, "May I please the court? I represent the United States of America." And I knew I was home. I knew I found my passion, and I charge you to find your passion, because you can't do the hard things you're going to need to do to be successful unless you follow your passion. Second, strive for excellence. No matter how small the assignment, always do your best. We have signs on the wall in EOUSA. Excellence first. That should be your mantra as you live your life, and it's how you practice law. Thirdly, be prepared to work very hard. I mean work very hard. To become proficient in the practice of law, you're going to have to work very hard. Malcolm Gladwell has an interesting book titled Outliers, and he talks about what it takes to be proficient. And he studies Bill Gates Jr., he studies the Beatles, and he examined Gates and what made Gates such a wonderful programmer. And he found out that when he was in high school, he went to a private high school, and he had access to computers. He'd spend all day working on computers. Then at night, he'd come home, and after his parents went to sleep, he would slip out and get on a bus and ride over to the University of Washington, where the computer lab was open, and it was free, and he would spend all night programming and then come back, slip back in. His parents never knew he was there, but he spent just all kinds of times programming. The Beatles. The Beatles were poor. They were struggling in Liverpool. So to make ends meet, they would go to Hamburg, Germany, where they would work in nightclubs and strip clubs, playing day after day, late into the night, every night, over and over again. Gladwell says that he thinks to become proficient at a task, you need to spend 10,000 hours doing it. Now, the law is the practice of law, and to become proficient at the practice of law, it will take, I think, 10,000 hours. So get started, particularly when you're young. If you really want to excel, develop good work habits and be prepared to work very hard. Fourth, be respectful and courteous to everyone. I expect you to be respectful and courteous to the dean, but I think you should also be courteous to the person who's going to come in here and clean up after we're done. Each is a critical part of the team that makes the law school work. Each is a human being that has something to contribute. And you never know. Remember the movie Good Will Hunting? The smartest guy in the math department was the janitor cleaning things up. You just never know. And they're decent human beings, so treat everybody that way. I'll tell you a personal story. As a youngish lawyer in the Justice Department, I got promoted to be a supervisor. And there were a group of some younger lawyers who I supervised. And I tried to do the best I could. And I developed friendships with some of those supervisors, some of those people I supervised. One of them has remained a friend of mine for 25 years. That guy's name is Eric Holder. He's now the Attorney General of the United States. I'm so glad I was nice to him when he was young. He's now my boss. We have a fondness for saying in Washington, D.C., that the elevators go up and the elevators go down, and you can never be sure who's going to be on those elevators. So be nice to everyone, and it's the right thing to do. Fifth, be open to new experiences. Be willing to move out of your comfort zone and try something new and different, to grow and stretch yourself in a different direction. That will help you so much. And sixth, learn from every life experience. When you finish it, I've learned more from the cases I lost than the cases I won. After you've completed a project, after you've done something, go back and reprise it in your mind and see what do you think you did well, what could you have done better, and learn from that experience. It never ceases to amaze me. The Department of Justice has so many smart lawyers. They are just, every meeting, there's Supreme Court clerks sitting there. Court of Appeals, they're like ants. Court of Appeals clerks are like ants in the Justice Department. They're just everywhere. Some do exceptionally well, and others don't. And one of the differences is that some of those super smart people don't seem to be able to learn from their life experiences. They can't take what happened to them today and apply it tomorrow. It's almost like, for those of you, if you ever see Groundhog Day, it's like they live the same day every day over again, and they make the same mistakes. So for you young lawyers, again, follow your passion, strive for excellence, work very hard, be respectful, be open to new experiences, and learn from every life experience. Now, in closing, I want to tell you how much I've enjoyed working in the Department of Justice. Not only has it been incredibly interesting, it has been extremely satisfying to serve in the public. I often tell Bunny that if I were rich, I'd do the job for free because it's really not work. She says, don't get any crazy ideas, Marshall. I urge you to consider public service as a career. The satisfaction that comes from serving a cause greater than oneself cannot be underestimated. In fact, I can't count the number of times that former United States attorneys or assistant United States attorneys have come up to me and say that being a federal prosecutor was the very best job I ever had. That's because it was a job that mattered, not just to themselves, but to the public they served. A principal role of responsible government is to protect and enhance the lives of its citizens, to provide for the common good. The hardworking men of the Justice Department do this every day. So for those of you who have the energy, the integrity, and the dedication to make a difference in our society, I urge you to consider public service as a career. It's worth it. Thank you, Dean. Thank you, Ihlenfeld Family. And if there's time, I'd be happy to answer some questions.
I should apologize. You may not realize that many students had 1 o'clock classes, so hence the slamming doors. We try to minimize it, but we weren't entirely successful. We do have some time for questions, and if you would come to the microphone, that would be very helpful. That way they'll be recorded for everyone. Thank you.
Hi, Mr. Jarrett. It's very nice to see you again.
Good to see you.
I'm Ann LaFaso, the labor professor here.
Yes.
I'm curious. I'm interested in the prosecution at the southwest border.
Yes.
And one thing that I find it, although you may have answered it by talking about the drug cartels, but I found it interesting that we seem much more concerned about the southwest border than our border with Canada. And at first, I always thought it was that there was issues of terrorism, but the terrorists that came in 9/11 came in during Canada. Can you shed, is this mostly because of drugs then that we're concerned as opposed to terrorism?
I share your concerns about all the borders and the northern border as well. You are correct. The one terrorist that got in who was going to blow up the Needle in Seattle came through the north. And the north, in many ways, is more porous. So we're worried about terrorists on both sides. On the south, though, there's tremendous human trafficking and thousands and hundreds of thousands of undocumented aliens coming across. And a lot of times they bring drugs with them, and they sometimes are vehicles for crime. So you're right, there's much more emphasis on the southern border, but we in the business are worried about the northern border as well.
Thank you. I also very much enjoyed your talk, especially the advice to the students. So thank you very much.
Oh, thank you.
Thank you so much for talking to us and bring us up to a normal person's height. Thank you for talking to us today.
Sure.
I was wondering if you could go back to some of the ethical comments you made and talk about the ethical issues that arise and how they're handled when the Department of Justice is forced to appeal a decision that the White House would otherwise agree with. I'm thinking of the recent decisions about Don't Ask, Don't Tell, which may not be the best example because I understand the President has recently said he wants Congress to repeal it, but I'm sure other situations arise like that.
I really don't, I haven't really tracked the sort of the byplay on that decision. I know that the Attorney General talks about the special obligation that Attorney Generals have. They're not just like any other cabinet official. Their first fealty, their first obligation is to the rule of law. Certainly when there are differences of view, if there are respectable legal arguments to be made, just like a private attorney will make those arguments on behalf of his client or her client, you do that. But if the law is clear, the Attorney General says, no, this is the law. Sorry, Mr. President, this is what we're going to do.
Thank you.
Yeah.
Thank you for coming today. You talked a little about the war on drugs and the border with Mexico, and there's been a lot of debate in California right now with Proposition 19 and what effect that'll have. And if that passes, what do you see the federal government's response being to that?
We haven't decided.
I think it was Holder came out and said that they would enforce the law, as it stands.
But what does that mean exactly?
Yeah.
That's Janet Reno used to say when I worked for her. Doing the right thing is easy. Figuring out what the right thing is, that's the hard part. So enforcing the law is easy, but what does that mean? Do we continue to enforce our federal statutes? There'll be a whole regulatory scheme that the state of California will adopt. Do we let that stand? Do we challenge that as violative of the Supremacy Clause? There are all kinds of really thorny legal issues, and I think being here today, I'm missing a big meeting talking about this.
Thank you.
Guess I got to readjust that. But thank you for coming here today. My question is, could you talk a little bit about balancing, what would be perceived as political pressures with the job of a U.S. attorney? I know, they're supposed to be apolitical. However, they are politically appointed. So if you could comment on that.
Sure. When the new U.S. attorneys come to office, come to school in Washington, I have a 3-day orientation. And Bill can tell you this, the first thing I tell them, you all got there through some kind of political process, but when you walk into the Justice Department, you leave your politics at the door. And the surest way to crash and burn as a United States attorney is to forget that. We make our decisions about whether to prosecute a case not based on who the defendant is, or who the victim is, or who the plaintiffs are, but what does the evidence require. Individual cases, the decisions on individual cases are made irrespective of political interests. Now, you have to be careful when you're talking about cases and policies. Elections have consequences, and administrations can decide generally what kind of enforcement priorities they want to have. So one administration can say, I want to emphasize the Project Safe childhood cases that I told you about, the pornography cases. Another administration may say, I want to emphasize and add resources to prosecute environmental crime. It's perfectly appropriate for an administration to make those policy decisions and direct the U.S. attorneys. This is an emphasis. We want you to put resources into this area and develop cases in terms of categories. That's okay. But when it comes to assessing an individual case, politics has no place. And as the head of OPR, there was more than 2 or 3 U.S. attorneys who I investigated and recommended they be fired because they forgot that important principle.
Thank you.
I'd like to add my thanks to you for coming here today. And your 6 points for law students to remember are ones that I jotted down. It's good for all of us to remember those.
Thank you, Pat.
There are a couple of things. There are many questions I'd love to ask you, but a couple of things. Just to follow up to the most recent question, how important is the career staff at the Justice Department as a bulwark against politicization of the department? And, of course, we had the end of the Bush administration concerns about the appointment of U.S. attorneys. And secondly, if you have a second, if you could put in a good word for learning administrative law as well as ethics, I'd appreciate that.
Okay. All right. On the first point, I want to say the Justice Department has 110,000 employees. When the election changes, there's a change, and I'm not sure the exact number. It's about 400 positions change. That means 109,600 employees are the same. They're there, and they are the institutional bulwark. We talk about, all due respect, Bill, we talk about the political appointees as being the political tourists. They come, they go, and we are there. And so we're supposed to be the ballast. Certainly, they get to steer the ship some, but they can't mess with the fundamental greatness of the Department of Justice. And occasionally they get a little off the reservation. I did the investigations of the allegations that the department hiring had been politicized. I looked at the firings of the U.S. attorneys. I looked at the hirings of immigration judges. I looked at the transfers, hirings in the Civil Rights Division in EOUSA, and wrote a scathing report about it. I hope that report will serve as a lesson to other young kids, and that's what it was. It was young political kids who came in and got a hold of things, so that it never happens again. Administrative law is very important, and in fact, in some ways, it's more important than sort of federal court practice, because about 80% of the decisions get decided sort of below the waterline in the administrative hearings. So pay attention, take those courses, and listen. Did I do okay? Okay. All right. Thank you very much.
I want to thank you, Mr. Jarrett, for being with us today. You were truly extraordinary and gave us a gift of insight into the Department of Justice. And I think every one of us here today can see that you are a testament to integrity in public service. Thank you so very much. We're so proud you're one of our alums. Please join us in the lobby for a reception.